Hello, hello, everybody. Just turn that down. So, welcome to today's webinar. Today, we're going to be talking about an overhaul of the inspection contract. We have some wonderful guests with us. We actually have three different speakers joining us on live today. So, thank you all for being here. If you wouldn't mind, before I bring them on and introduce them, go ahead and say in the comments, so I know that you're here. I know that you can hear me. Just where you're from, who you are, what company. I love doing that and having like a conversation with you guys. The delay in this. Leah, welcome back. Hey, Matt, welcome back. I think you were on one earlier last year in like 2023. Awesome. Amy. Hey, Amy. I think this is your first one, right, Amy? Well, thank you all for being here. So I'm going to go ahead and remove this little banner, and we're going to go ahead and get started. Also, change up the music a little bit. So for the presentation today and the webinar today, we actually have InspectorPro Insurance coming on to talk about your inspection contracts. Obviously, liability is a huge discussion topic in the home inspection space, but I am not intelligent enough to speak on it. So that's why I've brought the masters here. So let's go ahead and give just a round of applause in your own office, in your living room for InspectorPro Insurance. Welcome, Bob, Eli, and Will.
Hey, thanks for having us.
Thanks for being here. Well, at this point, it's your guys' show.
Okay.
Thank you for being here. I'll put up your presentation and you let me know if you need anything.
Okay, awesome. Thanks, Wolfpack.
Darren, appreciate it.
All right, as soon as that thing comes up, guys, I'm going to take over a little bit and give you an introduction. But one fun thing is you have what I'm calling 3 generations of inspector insurance specialists. You can call us the 3 amigos. You can call us, but you have to call us specifically the good, the bad, and the ugly, because Bob's the good, Eli's the bad, and I'm the ugly. But there's a combined amount of experience here that's just really ridiculous. And so we're really excited to share with you kind of it's our focus the last couple of years, which is the actual inspection contract. If I give you a little bit of background in InspectorPro, I will tell you that in 2009, we started selling E&O and GL to home inspectors. And by about 2015, we were the largest E&O and GL provider for home inspectors in the nation. Way back when we started, we didn't want to involve ourselves in contracts at all, to be honest. We wanted to leave it with the attorneys. We didn't want to be held liable if things came up and we were wrong about something. And so we really delayed this project for many, many years. Up until about 3 years ago, we started the project and we put in thousands of hours of research, legal research, billed attorneys' hours, and we also used our specialists in the claims department to develop the contract that we believe best serves you in a claims process. So we're excited about it. I know that many of you may already be using our contract, but we've got some really great keys today, even if you don't want to use ours, that can help you improve yours and will help us if you're one of our insureds should you have a claim. To kind of show you an idea of what we deal with on an annual basis. In 2023, we had over 850 claims. We've rounded that. And we had 1,300 pre-claims. The pre-claims means that we helped you guys with client complaints, things where they hadn't made a demand or where your insurance didn't need to be used. But in defense only, we spent $12 million in 2023. That doesn't include settlement and expensive adjusting and all of those things. But we deal with a lot of claims, a lot of pre-claims, and the contract is our #1 tool when we're dealing with that. I will second all of that background with some personal information, and I didn't allow Eli and Bob to tell cute stories about their families today, but I'm going to use mine. because I believe that through them I've obtained or am obtaining, I think it's a daily process with children learning to communicate, but a master's in dispute resolution. I feel like I'm always in the middle of an argument with somebody. We're settling the argument between somebody. The other thing that I'm going to tell you is, just like Aaron has asked you in the comments section, I want this to be a little bit more interactive, but because you guys don't have the ability to speak, I want you to put those questions as they come up in the comments, and we have some pauses. We'll try to catch them as we go. But please ask your questions, ask the hard questions. We'll try to do our best and handle it. So I have to deal with complaints and disputes very differently in my family. With my kids, it's more of they have a complaint or an issue, and I get to educate them and deliver information, and then we work it out ourselves. A lot of your clients are going to be that way. With my wife, the cost of defense is always way more than the settlement. So I always settle very early. I know that's not a popular topic in the home inspection world or in the insurance carrier world, but the legal system that we live in just requires settlement. That's the way these things are resolved, 99% of them. And sometimes it makes a lot of sense to get out of a lawsuit yourself for less than it would cost you to defend. There are times where we need to defend you to develop precedent and all sorts of things, but absolutely, please understand that sometimes there's going to be settlement. Now, with my last child, he's a little bit different. He's the youngest of 4 boys, as you can see. That picture in there is a couple years old, so he's like 2 in that picture, and he's 5 now. He speaks like he's 15 years old, and he talks back to everybody that knows him. He's a little bit different. We say that he's a savage. So I had an experience with him about, I don't know, it was a couple months back, and he came home from school. This is Bowen, age 5. And he came home from school with an incident report, but he had an envelope, and he was super excited. It said, to the parents of Bowen Colton. He brought it to me, big grin on his face, and I opened it up and I started to read it, and I had to turn my face away because it was funny to me, and it didn't really reflect who Bowen was, but I knew there was no doubt in my mind that this happened, even though he denied it. So the incident report said, while walking to early childhood pre-kinder playground, 3 elementary age students came over to Bowen, conversation there unknown, and before Bowen walked away, Bowen showed the girls his middle finger and said, losers. Now, that's not something a dad should probably laugh about, but Bowen is just that savage. And the people that got in trouble because of this, it wasn't Bowen, it was his older brothers that likely taught him how to do it. He then denied completely to the teacher that anything had happened and that he was mad, and she said he went on to play as always. So you guys will also get some of these savage clients that you have to deal with. And I promise you that your inspection contract is the greatest weapon in interacting with it. This is how Bowen goes to school on a normal day. He was mad he couldn't find his hat today when I went home for lunch. So let me go a little bit farther into home inspector agreements, because the #1 issue that comes in with coverage for home inspectors is that the agreement is not properly executed. And by that I mean signed prior to commencing the inspection. So everybody loves to blame the insurance carrier in this situation because they're the ones that have developed the clause. But let me tell you why they've done it. And we weren't the first to do it, and we were very reluctant to do it in the first few years. But what we realized is that in almost every state, if that agreement is not signed prior to the inspection, it is invalid and unenforceable. And so to not have it signed prior to inspection is just like not having it at all. So 2 things happened in court. The first one was it got thrown out right away because it wasn't properly signed. The second thing that happened, and which was more common at the time, is home inspectors were collecting the money, doing the report and inspection, and then asking the client to sign the agreement after the inspection in order to get the report. This fueled the plaintiff's attorneys because they were able to argue that their client had to sign under duress, that it was a give it or take it. They paid for their inspection, and now they're forced to sign a contract. So your contract, it's not just a concern from a insurance coverage standpoint, it's a concern from a legal and enforceability standpoint. And it will only help you and us if it's properly executed. And then the call that I hate getting the most is the one where a client calls me and says, I don't have coverage because I didn't get my agreement signed. In fact, if a client calls me and says I don't have coverage, that's not a call I ever enjoy having. But those types of things do happen. So you guys have heard enough from me for now. I'm going to turn this over to Eli, who's been with InspectorPro. It's been about a year, right, Eli?
Just under a year. Yeah, just under a year. It was last August when I got in with InspectorPro. So it's been awesome. I've been learning a lot from Will, been learning a lot from Bob. He said the 3 generations, they've passed him a lot of knowledge. So that's been fantastic. And really what we want to do is, along with what Will said, is help everyone understand a couple of things and a couple of clauses to put into the inspection agreement to provide the best mitigation of risk as well as protection possible. So really we're going to be talking about 5 major things. The first being the standards of practice. We're going to jump into the limitation of liability, a statute of limitation, an arbitration clause, and finally removing any unnecessary items. Now, along with a couple of other clauses, these are going to be the biggest 5 that we look for and typically require within inspection agreements to provide you with that mitigation of risk and protection that you guys need as you're going through your inspection. So let's jump to the standards of practice. Now, it's different per state. The first thing you have to recognize is, does your state require their specific standards or the state recognized standards of practice, or do they go by an association like InterNACHI or ASHI? There's 30 states that have their own standards of practice, anywhere from Alabama down to Tennessee. Now, standards of practice are typically pretty similar nationwide, but there are certain states, and Will and Bob jump in at any time, that do have certain aspects within their standards of practice that are specific to that state. And so if we jump to the next slide, Will.
Yeah, and I would add, Eli, that if your state has a specific standard of practice, many times the state also outlines that that is the standard of practice that is to be used. And that's the one they will argue in the courts. So even if you're inspecting to ASHI or InterNACHI standards, your contract and report should reflect that specific state. Florida is one of those states.
Definitely. Now, there are a few states that have, the ASHI, the InterNACHI, but states like California, Maine, South Carolina, they all have, California has CREA, it's a specific standard. Maine has ME-CHIPS along with the ASHI or InterNACHI. So some states recognize multiple standards of practice. Just like Will said, we recommend having your specific state standards of practice. We would hate to have agreements thrown out in a court because you're following the wrong standards of practice. That's pretty drastic, but we really want to make sure that we have the correct standards so there's no confusion, nothing like that. Now, I know we just dumped a bunch of information on you. Is there any questions that coming through the comment section? Amy says South Carolina uses ASHI, if I'm not mistaken.
Some of the states will set a standard, but then they'll reflect to the ASHI or the InterNACHI. I'm not sure on. What do we got? South Carolina on here? Do we list one of them? They must be one of the ASHIs.
As far as our research goes, follows the state standards of practice. Should just be right there below Maine on the right side of the page.
Yeah, they may just they may mirror the ASHI standards. That might be the thing there. We'll look at that.
Amy also follows up and says, yes, what is meant by SCSOP? So it's the South Carolina standards of practice, their state required standards of practice. Great question, Amy.
Awesome. We'll pause a little bit longer just in case you guys have anything, and then I'll just kind of pick back up. Don't be afraid to ask your questions at any time as well. You can throw it on there, and we'll try to get to it when we can.
Yeah.
One major thing is that if you do inspect in multiple states, you need to make sure that you're using a contract that reflects the state you're inspecting in. Also, your insurance is going to require that you be licensed or anything like that. So be sure that you're following licensing and certification guidelines, and that you have a contract for each specific state. This is a really simple example of a standards of practice claim. We get a lot of things like this. Most of the time we issue what's called a denial of liability, which is just a letter from the insurance carrier outlining the case and why you're not liable. But this one's really simple. The claimant alleged that the inspector didn't report and identify the presence of a septic tank. Now, I know that there are some standards of practice that require you to report whether it's private or public. But in this situation, we're in the state of Massachusetts, and their SOP reads like this. The home inspector's agreement contained the Massachusetts SOP. It states identification of septic tank falls outside the scope of inspections. And they also say that they are not required to determine whether water supply and waste disposal systems are public or private. So in this situation, it was really quite simple. We won. It was super exciting, right? Nothing was paid out. It was a $0 incurred, what I call a $0 incurred claim for our insured. They paid no deductible, and that was an easy one to get around. Now they're not all obvious. They're not all that easy, obviously, but the SOP will help us a lot of times. The limitation of liability is probably our #1 tool, however. It's our #1 tool in the pre-claims process. It's the #1 tool in your communication with the insureds or with your clients, I apologize. And it's even the #1 tool when we go clear into the litigation or mediation or arbitration process. Trying to get that limitation enforced is the #1 tool for us. And it's interesting, Eli but Eli makes a lot of calls regarding the contract and has a lot of conversations with insureds who are emotionally connected and invested into their current contract. That's the #1 thing. It's interesting, these contracts have come from many different places. Sometimes it's an association. Sometimes it's the association's copy from 15 years ago and then instead of the one they did this year. Sometimes it's an inspector taking another company's agreement and copying it, or taking multiple agreements and creating their own. Or maybe they hired a local attorney. In all of those cases, I've discovered that the inspectors are emotionally connected in most cases to their contract. And the second thing they argue about is our limitation of liability. Now, with InspectorPro, our recommendation is a multiple of the fee as the limit of liability. Now, that doesn't mean that you can't be liable for less than that, or that you can't be liable for the fee or try to enforce that. That means the maximum that you can be liable for is the multiple, in this case, 2 times the fee. The reason we like that is because it is more enforceable. It shows that your inspection contract is worth, or your inspection report and services are worth more than they paid for it. And it makes the courts and the judges and everybody feel like you've got a little skin in the game. Did I miss anything there, Eli?
No, I was just going to say the same thing. Really what we want to show in these inspection agreements is negotiability. We don't want our inspection agreements to look one-sided or a list of demands that the inspector has that the client has to follow to the T. But we want to show that we have some skin in the game. And in our experience, we've been able to stop claims quicker, therefore saving our inspectors time and money, making sure they can get back to their inspections and doing what they like and making some more money. So couldn't agree more, Will.
Awesome. We got Bob back. Bob's got slow internet in Georgia today. So, but we hope that he gets, oh, he's back. Good. Got your camera back. Bob, have we missed anything yet?
No, you guys are doing a great job if you can hear me.
Yeah, we can. Good. And that was clear, Bob. So if something comes up, just be sure to share it. Okay, let's jump forward. Well, this isn't working now. There we go. There are states that don't allow a limitation of liability: Massachusetts, West Virginia, and Wisconsin. People always argue with me that California doesn't allow it, but they do. It just has to be a multiple of the fee. You can't limit your liability to the fee in California, but you can make it 2 or 5 times. Our contracts list 2. So what's the difference?
Will, sorry to cut you off there, Will. But the awesome thing about having a state-specific inspection agreement are there's also states like New Mexico who have a specified amount of the limitation of liability. So that's all the more reason to have your correct standards of practice as well as a state-specific inspection agreement to really make sure that we can cover all bases.
Yeah, New Mexico has a high limitation of liability. What is it, like 300,000?
250,000.
250. It's wild, but they're also required to carry that much insurance, so that's good. I won't go into deep with this. We don't love liquidated damages. We love limitation much more than liquidated damages. Part of the reason is liquidated damages is really hard to measure because it includes a whole bunch of non-factual things and pain and suffering and all of those things. So if you have a liquidated damage clause in your contract, that's one of the things at the end of the conversation that we're going to recommend that you take out. Yeah, I kind of covered that. Liquidated damages clause retain the right to challenge or validity in court. Courts rarely find limitation liability clause to be unconscionable. That means unreasonable or unfair. Here's a limitation of liability claim example. And this is interesting because sometimes I look at it and I go, if this guy would have had a multiple of a fee, he would have been responsible for the entire amount. But he got a complaint from a client that he'd inspected a few months prior that he had missed a shower pan that was leaking. This is the picture that the client sent him, and you can see maybe drill holes or something here where the water would have been getting through and a really wasted drain anyway. And what we discovered as we went through this is that even in his picture, and you guys probably can't see that well enough, but in a close picture, you can see that those same holes were there at time of inspection when he was testing the tub. So in this situation, he was technically liable, but his contract actually allowed him to limit that liability. The inspection fee was $404, and his total liability was twice the inspection fee. Now, I think there's two things that could have happened here. One, the inspector could have felt really bad and just paid the entire $1,419. It would have been under his deductible. But in this situation, we were able to get him out of the complaint for less than that because of the limitation of liability in his inspection contract. Now, I'll go a little bit farther in my belief that maybe just paying the full amount was okay. I think that there's marketing expense is what I call it. And every once in a while, it's going to make sense to settle your situation, especially when it's a minor miss like this. So, but our claims people can kind of interact with that however you want them to. I shouldn't say it that way. They're going to have their opinion on how it's done. And in certain situations, they're going to tell you it has to be done a certain way. But in this scenario, I bet they would have let you pay the $1,419 and get a signed release. So that's a nice. Okay, so it doesn't look like we've had any new questions come in, but I would love some.
Mm-hmm.
Maybe we're just too good of teachers.
Man.
Yeah, we're
hard to be us, huh?
Okay, awesome. Well, let's move on.
Okay.
I think this is you, Eli.
Yeah. So the third thing that we always talk about is a statute of limitation. Now, these are going to be specific to your individual state. Really what it does is it limits your customer's ability to file a claim against your business after a specified period of time. That looks different for each state. And so we have a list of some of the states that the statute of limitation goes into. Some states have 1 year, some states have 2 years, 3 years, up to 5 years even in Florida. So it's really interesting because, and this is really why it's important to have it in the inspection agreement is, for example, a state like Florida, the statute of limitation is 5 years. Now, by including the statute of limitation in the inspection agreement, we can actually limit it down to 1 year, which is absolutely awesome. So instead of having your liability for 5 years, limited down to 1 year. A lot of inspectors say that maybe putting the statute of limitation inside the inspection agreement is like putting a target on their back, right? That their clients are gonna mark it on the calendar 1 year from the inspection and try to get their money back. But the awesome thing about this is, again, we can limit the liability down. We can also make sure that if there is anything to arise, we can take care of it as soon as possible. Will, do you want to add anything to that, or does that basically cover all of our bases there.
Sorry, I do think that we should add a slide and discover, there's a few states out there where the statute starts from discovery of the issue, not from the date of inspection. Most of you are going to be from the date of inspection, whatever that statute of limitations is. But there are a few states that do it by discovery, which is wild. And we have dealt with a few claims through the years. Pennsylvania, for example, with the 1-year statute, we've dealt with claims that we've had to defend beyond the statute. And it's just a whole lot of work to get it enforced sometimes. But most of the time, if you're beyond that statute or contracted for the shorter period, it's a really easy thing to get dismissed. So
now we do have a question from Austin, and I'll go ahead and read it really quick. It says, we have separate addendums for ancillary services that are added to the main inspection agreement, depending on services selected. Is there a reason we can't just have everything always listed in the main inspection agreement? That's a great question, Austin. If you're specifically talking about our inspection agreements and our policies, we within your traditional residential inspection agreement, we have a section that talks about radon, lead, polyurea, formaldehyde, feces, things like that are excluded from our policy. Now, if you want to do a mold test or a radon test, we do recommend adding those in as an addendum, because those are typically excluded from the policy, and you can have an addendum to add those in. So that's kind of why we have the addendum agreements. We also have standalone agreements. If you're just going to the house to do a radon test, or you're just going to the house to do a mold test, we also have separate agreements from that.
And I would add, because Austin is using our agreements, Austin, if you want to send me something, I think you'd have to add all the addendums, and then maybe it'd have to be like elected or not elected. But I think you could really create one big master agreement for all the services that Waypoint offers or any of your companies offer, and then the client would somehow have to elect or not elect, sign or not sign, to do it that way. That, I guess, that saves you time from creating a bunch of multiple versions if you're not, doing the pest all the time or the mold all the time or all of those things. But great question. Thanks, Austin.
Yeah, and that's a great answer, Will. We're definitely open to making it work for you guys. So we do have a claim with the statute of limitations. So the claimant, the inspector does an inspection. The claimant comes back and says that there is significant damage and rotting to the siding, flashing, and the deck of the home. And he says that they were missed during the inspection. The claimant then demands $85,108 for the claim. Now, after reviewing everything, our legal team did determine that the defects were missed by the inspector, and additionally, we estimated repair damage to the amount of $650,000. Now, this is a little bit of a hairy claim because the inspection agreement did not have the state standards of practice. It did have the statute of limitation. It did not have liquidated damages equal to 1.5 inspection fee, and it did have the dispute resolution going through the small claims court. So the inspection date was completed on September 2nd of 2021. And after, a month or so going back and forth and looking through everything, the complaint was served and stamped on 9/8/2022, which is 6 days past the statute of limitation. I believe that this happened in Tennessee, which has a 1-year statute of limitation. Now, the awesome part about this is when the defending counsel, realized that we had the statute, or the inspection agreement had the statute of limitation in there, they revamped. They tried to settle at $10,000. We ended up saying, hey, we'll settle at $5,000, and that was what we ended up settling at. So because we had the statute of limitation, and it's 6 days past the limitation, initial demand was $85,108. Estimated damages were $650,000. We ended up settling for about $5,000, which is a huge win on our part. And there's Shaq doing a little shimmy for everyone. Who doesn't like Shaq, right? Any questions about statute of limitation and for that matter, limitation of liability or the standards of practice, specific inspection agreement questions, we'd love to answer anything you guys have.
I have a question, Eli.
Yeah.
If it was past the statute of limitations, why'd you settle?
That's a great question, Will. It's a great question because sometimes there's still defense costs. Sometimes there's still, we have to pay lawyers and things like that. But I think it's a huge win that we were even able to settle for $5,000. And that comes, from your insurance agency. And I'm glad we were able to get it taken care of at $5,000.
Yeah, awesome. Let's see if Bob's mic will work. Bob, what do you think?
Yeah. Ask a better question.
Well, it's interesting, right? What do you think about why did they, since it was past the statute of limitations, why did the insurance carrier and the attorneys still decide to settle?
I think it was just to close it out. Nobody's really going to pay any attention to a $5,000 claim. And that was really an ugly claim for $650,000. We're talking some big dollars. So for me, as an underwriter, I would say if I can get off for $5,000 and not have any more court costs, and maybe they might appeal that 1 year statute. You don't know. So $5,000 is a quick, easy way to get out, and he doesn't have to keep looking over his shoulder. Well, what are they going to do next?
Yeah, awesome. Exactly. Just because, so all these things that we're sharing, the limitation of liability, the statute of limitation, the SOP, they are all tools in either eliminating or settling your claim. Just because we had a good case for statute of limitations, we would have still had to go to court. They could have fought it. There could have been a lot of billable hours. I think that the plaintiff attorney, the client's attorney, felt like his case wasn't very strong because of that statute and was very happy to get whatever he could. But if we go to trial, we're going to spend $20,000 to $25,000 at least.
What state was this?
This was in Tennessee.
What state was this in?
Tennessee.
Yeah, I would pay that $5,000 instantly in Tennessee to get out. I mean, I wouldn't mess around at all.
Yeah, if you're in Tennessee, the only state that's harder for us.
I'm probably not real.
Yeah. The only state we dislike more than Tennessee for defending home inspectors is New Jersey. But I will tell you, in 2012 for the InspectorPro insurance program, New Jersey and Tennessee combined for more than 65% of our total losses. Most of that was New Jersey. We've been able to correct a lot of the stuff in Tennessee by contract, but New Jersey's just still a really hard one for us. Bob, who we call the godfather of home inspection insurance, pulled out of New Jersey before any of the rest of us figured it out with his program. So helped us keep alive, helps keep your rates down that we're not there too. So this brings us to the kind of the last
program.
Your old program. Yeah, we've converted him.
Right. Not my current program.
We still give you credit for building a good program, Bob, and you help make ours better too. So the last thing before we tell you what we want you to remove from your inspection contract is something that we believe is so important for the difficult claims, and that's an arbitration clause. So your contract should outline options for your clients to resolve claims. One that we want you to avoid absolutely is mediation. The reason we don't like mediation is because it rarely results in any decision. It's expensive, and then you have to continue to move on. So when you're in a mediation, basically you hire a professional to make a decision. They don't have binding authority, so they take you to separate rooms or they take you to the same room and they try to get you to agree to a settlement, something that appeases you both. The reason this doesn't work most of the time is because 80 or 90% of the claims for home inspectors are frivolous. So the inspector shows up and says he's not responsible. So if you have a mediation clause, take it out. But you still have to have options. Our preferred dispute resolution is one pre-claims. You're not going to put that in your contract. But if we can get rid of things early before they become claims or demands from your client, it's a big thing. Small claims court is very simple. It's affordable. It's for smaller claims issues. You don't have to pay attorneys, so the expenses stay lower. And you literally show up and deliver the facts to the judge, or you've already delivered them, and he makes a ruling right there and you're done. Those can be appealed, I believe, though. Somebody correct me if I'm wrong. And the last one is arbitration. So arbitration is interesting because they basically hire a retired judge or an expert in the field, and they have binding authority to make a decision on your case. You still pay to go to arbitration, but for us, what we've discovered is that it's a quicker process, and it's a process where the contract is more regularly enforced. So we're more likely to get your limitation of liability, your statute of limitation, all of these things enforced in the arbitration process. We have very specific opinions on which arbitration companies to use, and that is CDRS, that's Construction Dispute Resolution Services, or Resolute Systems. The reason we like these two is they're a little bit cheaper, they're a little bit more construction claim oriented, and they've been more likely to enforce your contract. The ones we want you to avoid, if you have either JAMS or American Arbitration Association, AAA, on your agreements, please remove them, even if you're not with Home Inspector or with InspectorPro, and add CDRS. You will come out on top more often than not for using them rather than the other two. And those two are also expensive.
And that's a great point as well. American Arbitration Association, just on top of that, takes claims, and correct me if I'm wrong, Will, but from any industry on any given day. And so they don't necessarily specialize. And so, you know, just like what Will said, the CDRS are more likely to uphold the clauses within the inspection agreement.
Yeah, in most cases, is Bob going to add something? Oh, no. In most cases, the arbitrator is a retired judge or a retired attorney. You will get some other people, claims professionals, those types of things. Bob, did you have something to add? Nope. Okay, so I've got an arbitration claim.
One of the big issues of using JAMS or triple is that they both allow for discovery, and home inspector claims, there's not a lot of discovery to be made, but attorneys love discovery because it's cheap for them to do and they make a lot of money off of it. So that's why I've been CDRS. I know the owner of the company. I've met him. He's a wonderful guy. But I really strongly recommend using the CDRS.
Awesome. We don't go too deep on these claims. We probably should design a presentation once that is just so claim heavy and detail oriented. I will tell you that when Eli or Bob or I are studying a claim, we could study it for hours and still find new detail. It's just really interesting to read the court dockets and all of those things. But this one's fun. But the claimant alleges that upon purchase of the home, they sustained financial damages and bodily injury. And there's a whole list of things that they claimed were missed. The first one was they failed to identify moisture intrusion and water accumulation. The inspection report actually included and recommended areas for follow-up about moisture and to mitigate it. The mold, that there was mold, this was outside the SOP. I do believe that inspectors should report on potential and recommend areas for follow-up. But I think when you're recommending that moisture be mitigated, there's probably some comments regarding potential growth and those types of things as well in your disclaimers. Failure to identify the previous owner smoked cigarettes or used nicotine. Obviously, that's not part of your SOP and not something you should report on. Plus, I don't know how they discovered it. You know, maybe did they buy the house sight unseen? Did they never walk through it? Was it not disclosed? There's a lot of things there. Failure to identify that the property contained poor ventilation, obviously outlined outside the SOP. Failure to identify the plumbing stack contained within the home requires replacement. Inspectors not required to offer an opinion on adequacy of structural systems and components. Structural defects, obviously you're not required to report on engineering issues, architectural issues, or construction defect issues. Obviously, you should report on signs of potential structural damage, but I don't have the details on this one. I'll have to study exactly what they were complaining about. And the next one was, and the last one, that the roof had deficiencies, and they reported the roof as having heavy wear and in need of replacement in the report. We see this all the time. When I tell you the claims are frivolous, it's almost always outside the SOP, didn't exist at time of inspection, or in the actual inspection report. If I was to ask you guys on the comments side, if you can tell me what percentage of your clients do you believe actually read your report? I'd love to see what your opinion on that is and see if it matches with what people have told me in the past. So this inspector had a good agreement, and they gathered the signature 2 days before the inspection. They outlined the use of arbitration, so we were able to get this to arbitration. I do have other claim examples where we spend a whole bunch of money and then end up enforcing the arbitration clause and go to arbitration. Go ahead, Bob. I think you got something. Nope. Or he's freezing out. Matt says 5 to 10%. That's about what I hear, Matt, actually, 5 to 10%. The initial demand was $89,715, and we were able to settle. There was actually no judgment entered here. There was no limitation liability clause. It was just there's no liability. There's nothing to be done. And now this ruling is binding, right? This ruling can't be appealed. And the inspector paid a $750 deductible. Now, why did the inspector pay the deductible? Well, there was an expense to go to arbitration and some expense to adjust the claim and some other things. So there was an amount, and then he paid half of his deductible because with InspectorPro, if you have a pre-claim and you report something before a claim and it later turns into a claim, your deductible gets cut in half. There is also, Will Ferrell's my favorite, by the way. There is also benefits on your InspectorPro policy with your deductible. The first one's the one I mentioned, the early reporting. There's built into the policy a diminishing deductible, which means every year you go without a claim, you get a 10% deductible reduction in the event of a claim. And that maxes out at up to 5 years or 50% of your deductible. And then if you're using the InspectorPro model inspection agreement, we give you $1,000 off of your deductible for the claims where you've used our agreement on that claim and had it properly executed. Now, if you add all these up every once in a while, you get below zero. We're not going to pay you if you have a claim a negative deductible amount. So sorry, I can't do it. Wish I could.
That'd be pretty nice though, right?
Yeah, I had a claim. Now apply this to my next year's premium. It's like your tax return.
Yeah.
So, but no, doesn't work. If we can get it to zero, we hope you're all happy. So, and we've done all this, the pre-claims, the deductible discount, all of those things because we want you to send us the stuff early. The earlier we can get involved, the better. And that's just the flat out truth. Don't be afraid to call your agent and have a discussion. That doesn't mean you have a claim. Now, if you call me and you give me a bunch of detail and I tell you we need to send this and you've got a claim, that's okay as well. That doesn't mean it's going to go bad and your rates are going to hike and you're going to have a whole bunch of stuff go wrong. We get rid of a lot of the claims for $0 incurred for you guys, no deductible, and those types of claims don't affect your rates. The other ones, you got to get up to like the $15,000, $20,000 range to really start to get a decent effect on your rate. You might have a small surcharge for a small claim, but we're talking $50 to $100 maybe. So,
and I was going to say that statistically, we stop 90% of claims in the pre-claims process. And so you have full access to our legal team. You know, they help you navigate what to say, how to say it, and how to navigate the situation. So that's an awesome, awesome tool that a lot of our inspectors have appreciated.
Huge benefit, huge. Now we should have Trump up there going huge.
Yeah, you know, Austin even says InspectorPro's pre-claims team have been awesome to work with. Thank you. We really appreciate that, Austin.
You should say that Shmuel's your favorite.
Yeah.
We've actually been successful on a couple claims for you guys as well, Austin, on just getting rid of them as zero. They come in as pre-claims. We find a demand from the insured, and we've had good success. That brings me to another topic, actually, before I move on to the things that we take out. But we've tried to track for years why people have claims. And it's And the only trackable thing that we have is number of inspections performed per inspector. So we've noticed an uptick in claims when a single inspector does more than 300 inspections in a year. It the inspector's ability to report and write correctly and be trained and knowledgeable, those things are wonderful, but those people still get claims because they're getting sued for things that are frivolous. Even when you've done your job right, those things start to happen. So there's no secret recipe. Good inspector, bad inspector. I mean, obviously we discover a lot about the bad inspector through the claims process, but everybody gets claims. Claims are pretty non-discretionary, and I don't know what the word I'm looking for, but anyway, okay.
They don't discriminate. They don't discriminate.
They don't. Yes, non-discriminatory. That's what I was looking for. Eli, you're so great. So the last thing that we're going to go over, and then I'll give you kind of some response interaction. Start coming up with your questions right now for the end of the thing, because we got about 10 minutes left. But avoid additional verbiage that can be viewed as one-sided or often fought over. Now, again, I go back to what I talked about with inspectors being very emotionally and personally connected to their inspection contracts. I can tell you that many of those clauses that you are most connected with, that make you feel tough and strong and in charge, many of those clauses will cost you time and money in court, because they'll just give more things for them to argue about. But the biggest ones that hurt us are liquidated damage, again, because it's not measurable. The attorney's fees clause. Now I'll explain that, because attorney's fees clauses are a double-edged sword. Because if you have it in there, it also works against you. So if you lose a case, they can also go after their attorney's fees. What that does, I call it blood in the water for the shark attorneys. It just fuels their fire. It also means if they're able to get some type of settlement, they can also include in that settlement, because of your inspection contract, their fees. So if you have an attorney's fees clause in there, get it out. I do have a good example of attorney's fees clause in arbitration, where the arbitrator ruled to give us the attorney's fees clauses back, but I'd much rather have it the other way, because most of the time it works against us. And the last one is a hold harmless. It's just not negotiable, as Eli went over before. And you need to have a little bit of skin in the game, because you're collecting a fee for a service that you're claiming to be an expert at or a professional at. So hold harmless, they don't work. They don't hold up very often. They're one-sided and even unconscionable in some situations. I went over that. Okay, any questions, guys? If not, I have one more thing to share, Eli, and then and you got some of it.
Sure.
Okay.
Looks like Bob's internet is bad, so he's logged off. So it's just us two.
That's our loss actually today, guys. Bob's got some great input, and I love having him around. He's been a great addition to InspectorPro, and he sells the InspectorPro brand as good as anybody, maybe better than the Allen brand that he used to sell. Wish he was still here to see that. But we called him, we called him the Senior Ambassador is his new title, Eli. I don't know if you knew that. He didn't like Booth Babe, so Senior Ambassador worked better. But okay. What about adding TC PA language to the agreement for third parties we may be working with that contact clients after the inspection? Totally fine, Austin. I know that's really common with RWS or Porch or some of those things. Totally fine. We've had that approved all the time, and it doesn't really affect the rest of the contractor handling your claim.
Same with like home gauge and things like that. They'll add some stuff in there. That's totally fine as well.
Eli, is your email address eMorgan or?
Yep, eMorgan. Yep.
So if you want to email Eli because he's more handsome than me, it's emorgan@inspectorprotect.com. And he's also a great source for your contract questions, or if you want access to the contract, so you want to see them, review them, get them implemented. If you're with InspectorPro, I absolutely recommend you do it, and let's have those discussions as we go. So the last thing, and then I'll save you guys from having to listen to the rest of us, is we've done for years something called the 7 things you do when you get a complaint. And I'm going to answer Edward's question before we get there. What about those that utilize the 90-day home warranty for their inspections, which covers a few things? If something does develop as an issue was missed, wouldn't that help before going to insurance? Absolutely. There's a big difference between warranty and insurance, however. Warranty is designed to cover something that's failed after the fact, right? So if it worked at time of inspection and then it failed afterwards, then the warranty is really good. It's also a really good way to get your client to make official statements to another party about what really happened. And in many cases, they're telling it all went wrong and it's always been bad. And then when they call the warranty company and realize they don't get coverage if it worked when they bought the warranty, then they're telling them the opposite, and maybe there'd be a little bit more truthfulness to it. I think the two products work together very well, and I think the warranty is a great risk management tool, but it's not a solution for legal issues or anything. And if they don't like the warranty, they might still sue you anyway. So, or if you actually miss something, the warranty is not going to cover it. The last thing is the warranties are very limited, right? You guys know what your particular warranty limits are, but the biggest one I know of the industry is $25,000, and that's in only one category of that warranty. Many of these warranties are like a $500,000 or $500 mechanical warranty, right? So if somebody's AC unit went out, $500 doesn't do much for them. But yeah, they're a great tool. I think they're a great value upsell for your client, and a good revenue stream for you guys, hopefully. Aaron at Matt, if you registered for the event, you can come back to the link, watch the record. Okay, he didn't need me. Okay.
Yeah, Matt was asking if he'll receive a copy of the recording. So if you register for the event, you can come back to watch the link. But if not, it will not be sent to you.
So here's the last thing that I'm going to go over. And this is pretty important because you guys are getting calls from your clients all the time. And here's our tips. I will tell you that number 7 could be the first thing you do, right? You get an email or a call, voicemail from a client. You can contact your agent, is the way it's going to work. We can have a conversation, and then we can get the information to my pre-claims people, which is just my claims professionals. Shmuel Steinberg, who's my favorite adjuster, handles most of the pre-claims. He's phenomenal. Everybody that has ever worked with him, except for maybe one lady, has loved him. So that can be your first step. But the first thing you need to realize is that you don't admit fault, ever. Even if you know you're wrong, it can affect our ability to enforce your contract, and all sorts of things. You should be empathetic with the client, right? They're in a situation that they are upset about. You should understand that and communicate professionally and appropriately. You need to ask particular questions to collect information. Things like, when did you first discover this issue? What led you to discover? Has anything changed at the property since inspection? A lot of these complaints come in when they're in the middle of a remodel and they've ripped up the floor or the walls and they've found something. So if that type of thing happens and they tell you this is how they found it, it then can start the conversation about your inspection not being, it's visual, it's non-invasive, it's all of those things. So the next one is revisit the property. Now, when you're at the property, you're there just to gather information. And then you'll buy yourself some additional time by saying, hey, I'm going to go back and compare this to my findings from the day of the inspection, my report, my photos, my notes, all of those things, and I'll get back with you. So then you go back, you investigate those things internally, and then we get you with pre-claims assistance. Now, they can either just give you advice verbally, or in most cases, they can draft a letter. Now, this is a letter that comes from you, not from them. And it's important as you're interacting with this pre-claim situation that you don't mention that you're involving your insurance carrier. The state insurance commissions make the insurance carriers respond. It's law if the client believes in any way, shape, or fashion that the insurance company is going to be responding. So if you allude that the insurance company is responding, even if this is a pre-claim, now you've got what we call a claim. We'll still draft a letter, but it will come from the insurance company denying your liability, and hopefully it closes out at 0. But be very careful as you kind of go through that. Here's an example from Shmuel. It's unfortunate to hear about the issues you are having with your new home. So that I have a better understanding of the situation, please provide a detailed description of the issue, when and how it was discovered, and I will look into it, as I will look at the information as I get back to you as soon as possible. Somebody needs to rewrite that. This is Shmuel. Here's his normal response. Use the SOP, gather the facts and details, craft the response with the home inspector. So, did we have any other questions come in, ladies and gentlemen?
Looks like Aaron just wanted to remind everyone that the recording is also published on Wolfpack's social medias. So they should be there. They're recorded and published there.
Okay. Well, I'll finish you. If you have questions, we'll stay on for just a little bit, and I'll let Eli manage a lot of that. But I want to thank Wolfpack. I think this is a great group to support. I think they provide a value to the industry that was missing for many, many years. And the clients that I've spoken with have been very thrilled with their services. So if you're not already with Wolfpack, you should definitely check it out and see how it can benefit your business. InspectorPro's excited to be doing anything with them. So thanks for having us. If you have questions, that's my direct number. That's my email. You're welcome to call either of us or any of us, and we'll get you taken care of.
Yeah. Thank you guys so much for logging on with us today. Matt said, awesome job. Thank you so much. Thank you, Matt. We really appreciate it. If there are any questions, we'd love to answer them and help you guys out. So thank you very much.
All right, guys. Well, thank you. Thank you for being here.
You're welcome.
Thank you.
We'll just hang around for just a minute in case anybody has any additional questions. If not, thank you all for being here. We appreciate it. Big round of applause in our own homes for InspectorPro Insurance for being here. Will, Eli, and of course Bob for the time that he could be here. All right, guys. Well, I'll go ahead and end the stream here. And then if you guys do have any questions, feel free to go to InspectorProInsurance.com or reach out to them. I left their emails in chat as well. So if you guys have any questions directly for Will and Eli, you can reach out there. So thank you so much.
Awesome.
Have a good one, guys.
Aaron.
Thanks, Aaron. Thanks, guys.